Everyone, welcome to Save News TV. My name is AZ Hubbard, your host of Save News TV, and thank you so much for allowing us into your homes. Today, we are going to talk about Duane Youngblood request for an extension to reply to the case, a 30-day extension, and also he wants to have that extension so he can file an anti-SLAPP case against Bishop T.D. Jakes. In our last video, we talked about and read out the entire request by Bishop T.D. Jakes for the expedition of discovery. In that, if you watched the video, hopefully you did, and if not, you can go in the playlist or I can link it in the description. But he was offered the opportunity by T.D. Jakes for an extension, but he declined and did not want to have the extension. So now, as time passed, because his reply is due on the 26th of December, he comes up with a request to the judge, to the court, for a 30-day extension and to file an anti-SLAPP case. Now, one might wonder, where did, and today we're going to read out his request to the court. But before we get into that, we want to know, where did Youngblood get this idea? Where did he get the idea to file an anti-SLAPP request? We're going to read this out. We're going to read out the anti-SLAPP, and then I'm going to show you a video and answer the question on where this bright idea came from for him to want to file an anti-SLAPP case. And what is an anti-SLAPP case? We're gonna talk about that. Like I said, we're gonna read out the case, which is not as long as the other ones. This pretty brief. The letter, it's only a few pages, and then we're gonna show you a video, and we're going to define that, and we're gonna talk some more. So just hang on. So let me share my screen so we can talk about his request to the court. So let's read, everybody. Read. I feel like I've done so much reading, but anyway, I need some water. Okay, this is coming from Duane Youngblood to the U.S. District Judge William Strickman V. And he says, "Dear Judge Stickman V, I am writing as a pro se defendant in the above captioned matter to respectfully request a 30-day extension to respond to the complaint and to file an anti-SLAPP motion. I am currently in the process of attempting to retain local counsel. However, as I am only employed part-time, securing legal representation has proven to be financially challenging. I believe an extension would provide me with the necessary time to obtain appropriate representation and to prepare a thorough response and anti-SLAPP motion to dismiss. Your Honor, I have unwavering confidence that the court will discern the lack of merit in the plaintiff's claims, which I firmly believe constitutes a violation of my First Amendment rights. The United States Constitution guarantees that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. This fundamental right underpins my ability to share my life's experiences, truthfully and supported by evidence as protected speech. In support of my defense, I intend to present 7 sworn and notarized affidavits which corroborate the facts I have shared over the past 3 decades regarding the trauma I endured as a teenager as a result of the plaintiff's and others' actions. These affidavits will be accompanied by photographic evidence from the period in question, including images taken during the month I met Mr. Jakes and during events at the church where he preached. Additionally, I will provide documentation of complaints I have made to the senior bishop of Higher Ground, Always Abounding Assemblies, HGAAA, of which Mr. Jakes is vice bishop. These complaints include a conversation facilitated by Senior Bishop Sherman Watkins between myself and Mr. Jakes during a visit to my church between 1992 and 1993. At the meeting, I directly confronted Mr. Jakes regarding his actions, and he made a revealing admission that supports my claim. It is important to emphasize that I have expressed concerns about these events spanning multiple decades in the late 1980s, 1990s, and 2000s. Despite my consistent and publicly recounting of these incidents, Mr. Jakes did not see fit to file a defamation lawsuit against me during any of those years. This inaction suggests that Mr. Jakes himself recognized the validity of my statements or deemed them unworthy of legal challenge at the time. Furthermore, it is telling that Mr. Jakes actively participated in my 2004 ordination as a bishop of HGAAA, serving as one of the concessatories despite his full awareness of my public statements about his actions. These facts highlight the baseless nature of the current lawsuit and further affirms my assertion of truth. The legal principle at stake in this case is grounded in the precedent following established by New York Times Company versus Sullivan, which provides robust protection for individuals expressing opinions or recounting personal experiences, even if they are controversial, provided they are truthful or expressed without actual malice. Furthermore, in Hustler Magazine, Inc. versus Falwell, 485 U.S. 46, 1988, the Supreme Court reaffirmed that speech about public figures related to matters of public concern enjoys highlighted protection under the First Amendment. The United States Supreme Court decisions emphasize the paramount importance of safeguarding freedom of expression, particularly in cases involving significant public interest or personal narratives. I respectfully request the opportunity to include photographic evidence with the forthcoming filing to support my assertion. This includes 1. A photograph of myself as a teenager taken during the month I met Mr. Jakes. 2. A photograph of myself performing at the church where Mr. Jakes was preaching during the relevant time. 3. Photographs documenting my 2004 ordination ceremony with Mr. Jakes officiating. I contend that this lawsuit represents an attempt to silence me and suppress my First Amendment rights. It is neither lawful or defamatory to truthfully share one's life experience as I did during my interviews on October 28, 2024 and November 3rd, 2024. Plaintiff Jakes has used his position to harass and target me throughout the years, and as recently as November 3rd, 2024, had his son Jeremy Jakes reach out to me and threaten me on social media. This threat is what led me to seek legal counsel, as I was and am in fear of my life and safety. Upon information and belief, Bishop Jakes and his family have a reputation of having individuals who challenge them or expose their dirty dealings disappear throughout the years. And this is a screenshot of Jeremy D. Jakes allegedly stating, "In conclusion, I respectfully request that the court grant me a 30-day extension to secure legal representation and to prepare and file my anti-SLAPP motion to dismiss. I appreciate the court's understanding and consideration of my circumstances." All right, everyone. So that is his request to the court for a 30-day extension and so he can also file an anti-SLAPP case against, requesting dismissal. So let's see what is an anti-SLAPP lawsuit. It is a motion to dismiss. So we're going to read this right quick so you understand what it is. Strategic lawsuits against public participation, also known as SLAPP suits, or intimidation lawsuits, or strategic litigation against public participation, are lawsuits intended to censor, intimidate, and silence critics by burdening them with the cost of a legal defense until they abandon their criticism or opposition. In a typical SLAPP, the plaintiff does not normally expect to win the lawsuit. The plaintiff's goals are accomplished if the defendant succumbs to fear, intimidation, mounting legal costs, or simply exhaustion and abandons the criticism. In some cases, repeated frivolous litigation against the defendant may raise the cost of directors' and officers' liability insurance. So in other words, an anti-SLAPP is a lawsuit to defend against a SLAPP lawsuit. So in other words, what Youngblood is saying is that Bishop T.D. Jakes is filing this lawsuit frivolously so that he can just wear Youngblood down, and he wants to just, wear him out. So whether it's financially, emotionally, through litigation, to get him to shut up, and that, he has no right to share this. So Youngblood has filed an anti-SLAPP to dismiss the case, stating that pretty much that T.D. Jakes' lawsuit is frivolous and that it has no bearing, no ground for standing. So now we ask the question, where did Youngblood get this idea from? Most people don't know what a SLAPP or anti-SLAPP is, especially if they're representing themselves in a pro se lawsuit. They don't have an attorney or anything like that. How did he get this idea? Did he do an investigation or whatever? But anyway, no, that's not what happened. Let's see what happened. Now, this video, and of course, copyright we're using this for protection, copyright protection. So here we go. We have the disclaimer below. This is December the 11th, 2024, Larry Reid show. And on his show, he gives some advice to Youngblood. Now, in all fairness, he also gave advice to TD Jakes, but this was the advice that he gave to Youngblood. Let's listen to this.
Let me tell you what I think should be done. Now, this is for Duane Youngblood team. I think, because you're dealing with Jakes, who's a high public figure. Duane, if somebody got Duane number, tell them to come listen right quick. Duane, I think you.
Okay, so now this is where Larry Reid gives advice to Youngblood.
Should go into, you can get Blackburn to fix up everything, the lawyerize everything. Even if you do anti-SLAPP. But if you do anti-SLAPP, you need a lawyer. Without counsel.
Okay.
I don't think he should respond with counsel. Now, if you understand law or you just been paying attention to stuff that happened online.
Okay. So now let me ask you this. Is Mr. Reid an attorney? Would you take his advice? This is interesting what he's sharing here.
When somebody's very powerful and popular and a person of means, and you are taking somebody to court for defamation,
okay,
there's a way for you to end up losing the person that's the plaintiff. And one of the key factors, and you ended up filing this lawsuit and winning,
okay,
is whether or not the defendant has representation. Because every judge, if he represents, I think that's called pro se, and he's his own lawyer, immediately the judge and the court and the system is going to have compassion upon Duane.
Okay, can we guarantee that? Can we guarantee that? Generally, maybe yes, but it could be no. Maybe the judge won't have sympathy on him. Because I believe, if I found this for sure, TD Jakes and them have already found this advice because they're monitoring all of Larry Reid's videos because they have subpoenaed him. But okay, let's continue on the advice that he is giving Youngblood.
Even with him being a sexual predator and convicted, whatever, it's just the way of the court. And in every case, come on, think back, when there was a plaintiff that filed for defamation that was powerful and affluent, that allowed the defendant to get so much grace. I think you should respond without a lawyer, meaning get your complaint stuff and your answer done proper to respond, get the lawyerese, the language, but do it on your own.
Okay. So now, one thing, this is advice again from Larry Reid to Duane Youngblood, and this could turn out bad for Youngblood. It could turn out great for Youngblood, or it could turn out bad. It's going to depend on the judge. And if the judge is not sympathetic and Youngblood doesn't know the law and he's in there trying to fight for himself by himself, this might not turn out well for Youngblood. It's like that saying, what's that saying? A doctor that has himself as a client is a fool. A lawyer that represents himself in court is a fool. Now, those sayings might end up pertaining to Youngblood. It's his choice. He can go in there, like he stated to the judge in his request for an extension, that he can, if the judge granted, because the judge might not even grant the 30-day extension, because they offered him an extension to reply, and he declined. So let's get back on with the recommendation that Larry Reed has for Youngblood.
I think this is going to put you in a more favorable position, because right now what Duane needs is to not experience a lawsuit being won especially by default, against him. You don't need that. So that's me helping Duane. Now let me help Bishop Jakes.
Okay, so now in all fairness, we got to give it to Larry Reed. He gives advice to both sides. He gives advice to Youngblood. It's up to Youngblood to take it or not, legal advice. And now he's about to give legal advice to TD Jakes, and it's up to his team to take it or not. It seems like they might have taken some of this advice, but let's listen what his suggestion is for TD Jakes. Okay?
This is my opinion. In my opinion, what Bishop Jakes should do right now is to do a couple of more motions that show aggression, that you are not playing with him or with them other 1 through 10 people or 2 through 10 people that you're saying. Go ahead and name whoever you could name.
Okay. Well, it seems like that TD Jakes' team has taken Larry Reed's advice. And like I said yesterday, the previous video was regarding TD Jakes requesting expeditious discovery. And per Larry Reed's advice for him to name whoever he can name at this time, well, guess who got named first? Larry Reed. Man, sometimes you got to mind your own business, but he gave the advice, and it seems like his team, TD Jakes' team, took it. Let's hear what other advice he gave. An expeditious request to expedite discovery, and the case was filed less than 30 days. That is showing aggression. So they definitely took Larry Reed's advice. But unfortunately for Larry Reed, he's the first one to be named.
Show some kind of aggression, or you filing the motion paperwork, because he doesn't have representation. And somebody said, "Hello, Larry, talking on both sides." Yes, I am. I can do that. I just helped Duane. I'm helping TD Jakes. He don't have no lawyer for Pennsylvania. He's got counsel outside of that, but he don't have no lawyer for Pennsylvania. So paperwork him to death, and then you can win. I mean, ugh. And somebody was saying, "Now, Larry, why would you tell him that? If he really did something to Duane, then he needs to pay for it." Well, it don't have to be in court. Another piece of advice I would give Jakes is to pull the whole darn thing.
Okay.
To just dismiss it. It's going to make you look a certain kind of way, because I had to do that one time.
Okay. Well, Larry Reed, it appears that TD Jakes is not taking that piece of advice. He's taking the first part of the advice, but he's not taking the second piece of advice, at least not yet. Maybe he will dismiss the case, maybe he will not. But right now, He's not taking that piece of advice. He is moving forward full steam ahead. So let's finish listening to this little piece here, and then
I had to dismiss and then redo something on the back end and refile later on. I think he may need to dismiss this and find a way to come to the table and have a conversation. Because now at this point, you're going to have to pay Duane something because you dragged him to court thinking he was dragging you to court to get some money. Okay. And that wasn't the case. That was Blackburn's letter. Blackburn, that's the name. Just doing the regular lawyer stuff, and you discerned it wrong. However, I was told that he filed that to sort of scare some of the other people that is trying to come after him for a re-up and payment. Because it is alleged that he has paid other people off to stay quiet and not talk.
Okay, so what I'm gonna put the link to Larry Reed live show video, and you can go watch it for yourself. You can watch all of that video. I just wanted to show that where Youngblood received might. I'll put it this way. I don't know. I'm not a party of this. I just know what I see on the internet, just like you and just like you. But anyway, he gave advice to Youngblood in how he should proceed with his legal case, and it appears that Youngblood took his advice. Now, how this works out for Youngblood, we will not know until later on. He also gave advice to TD Jakes. TD Jakes took part of the advice also. He gave him two options, two suggestions. One is to paperwork him to death and name all the John Does that he possibly can, or two, dismiss the case. Well, TD Jakes elected to take the first part of the advice, which was start filing a bunch of paperwork and expedite it and let them know that you're not playing, and to name the John Does 1 through 10, as many as he can. Well, for Larry Reed, he was the first one named. So we will continue to follow this story. We don't have a dog in this fight. I have no earthly idea of what is going to happen, what is going to transpire. We will continue to work on this. Continue to like, share, and subscribe. Subscribe. Also, the legal documents from yesterday's video is in our members only section on the community tab. If you're a member of this channel on YouTube, then you are able to view those documents. I'll post those and other information about not just this case, but exclusive information. To become a member, you can join, hit the join button below and join to become a member, and you'll get that and other exclusive information. So if you would hit that like button, subscribe, share, so we can get this information out. If you'd like to support our channel, the information is below. And we have a video coming up for you. And so thank you so much. We're going to stay on top of this story. Stick with us, and we will be reporting fairly, squarely, and just the facts. Okay. All right. You all have a wonderful day. Thank you. Bye.
I'm writing lines to lift his name. No need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn. His love we adorn. Each melody, a testimony, hearts reborn. In every